Day to all of us, especially to our handsome and gorgeous colleagues. We are here today to discuss about the case of the Office of the Court Administrator versus LADAGA 350 SCRA 326, which was promulgated January 26, 2001. And to introduce the group members, may I call on the esteemed members of the group, please. So let's start with the group members. We have myself, Barrientos, Ferdinand Jr. We have Capa, Allan, Capricho, Mylene, Ibabao, Cheska, Angelie, Jamito, Joey, Ryan, Juinio, Sharon Ross, Musa, Ricardo, Pontillo, Ferdinand, Tagupa, Jonica Eva, and Miss Velasco, Krizza Mae. So to fully understand the case at hand, let us start the discussion with the facts of the case, which will be presented to us by Ms. Jonica Tagupa, Mr. Ferdinand Pontillo, and Allan Capa.
Thank you so much, Mr. Barrientos. In this case, the facts are the following. Attorney Misael LADAGA, branch clerk of Court of the Regional Trial Court of Makati, appeared as counsel for and in behalf of his cousin, Narcisa Naldosa LADAGA, an accused in criminal case number 84-885 for falsification of public documents. Appeared of said respondent or in said case was without the previous permission of the court.
In addition to that, he was on official leave of absence during his appearances in court as counsel of LADAGA. Respondent appeared as pro bono counsel for his cousin client Narcisa LADAGA. This is the first time that respondent ever handled a case for a member of his family who is like a big sister to him.
Executive Judge Josepina Guevara Salonga was aware of his appearance as counsel for his cousin. It was also emphasized that during all the years that he has been in the government service, he has maintained his integrity and independence. The only problem, he failed to secure prior permission from the Office of the Court Administrator before appearing in the Metropolitan Trial Court of Quezon City, Branch 40, acting as counsel for and in behalf of his cousin.
Thank you so much, Ms. Tagupa, Mr. Pontillo, and Mr. Capa. To tell us about what was the issue of the case, let us welcome Ms. Mylene Capricho.
Thank you, Sir Barrientos. So, based on the foregoing facts, the issue of this case is whether or not the respondent, Attorney LADAGA, in his several appearances as counsel, was engaged into private practice. That's all, and back to you, Sir Barrientos.
Thank you so much, Ms. Capricho. For us to know what happened to the case, let's proceed to the ruling of the court. May we welcome Ms. Krizza Mae Velasco, Ms. Cheska Ibabao, and Mr. Joey Jamito.
Right. Thank you, Sir Barrientos. I am going to discuss the ruling. The answer to the case issue is no. There was no private practice. Respondents charged under Section 7B, Paragraph 2 of the Code of Conduct and Ethical Standards for Public Officials and Employees. A similar prohibition is found under Section 35, Rule 138 of the Revised Rules of Court. Practice is more than an isolated appearance, for it consists in frequent or customary action, a succession of acts of the same kind. It was tackled in the case of Pifal versus Villanueva.
Yes, as a matter of fact, in the case of State versus Bryan, the practice of law fall within the prohibition of statute has been interpreted as customarily or habitually holding oneself out to the public as a lawyer and demanding payment for such services. And based on the facts, the appearance as pro bono counsel does not constitute private practice.
Moreover, although respondent's appearance did not constitute private practice, he failed to obtain a written permission from the department, which is required by Section 12, Rule 18 Revised Civil Rules. Section 12 states that there's no officer or employee that shall engage directly in any private business, vocation, or profession, or be connected with any commercial, credit, agricultural, or industrial undertaking without a written permission from the head of the department.
Thank you so much, Ms. Velasco, Ms. Ibabao, and Mr. Jamito. Before we enter this discussion, let us go to the question and answer segment for us to be better enlightened, just in case our audience has more questions in mind. This will be shared to us by Mr. Musa and I. I will be asking the questions, and then Mr. Musa will be giving us the answers. For the first question, If we correlate this case to the lawyer's oath, what particular line did the respondent violate? Mr. Musa?
Well, thank you, sir. In here case, the respondent violated second line of the lawyer's oath, which states, I will support the Constitution and obey the laws as well as legal orders of the duly constituted authorities therein. Here, the respondent violated Section 12, Rule 14 of the Revised Civil Service Rules, which states, no officer or employee shall engage directly in any private business, vocation, or profession, or can be connected with any commercial, credit, agricultural, or industrial undertaking without a written permission from the head of the department, provided that this prohibition will be absolute in the case of those officers and employees whose duties and responsibilities require that the entire time be at the disposal of the government. Provided further that if an employee is granted permission to engage outside activities, time so devoted outside office hours should be fixed by the agency to the end that it will not impair in any way the efficiency of the officers or employee. And provided finally that no permission is necessary in the case of investment made by an officer or employee which do not involve real or apparent conflict within his private interest and public duties, or in any way influence him in discharge of his duties, and he shall not take part in the management of the enterprise or become an officer of the board of directors. That's it, sir.
Thank you so much, Mr. Musa. In this case, the respondent was reprimanded. What is exactly reprimand? Is it considered a penalty?
Well, reprimand, as stated under Section 15, Rule 14 of the Omnibus Rules Implementing Book 5 of the Administrative Code of 1987, provides that a reprimand, whether given by the Civil Service Commission or of the head of the department or agency, shall be considered a penalty. However, a warning or admonition shall not be considered a penalty.
Thank you so much, Mr. Musa, for your wonderful answers and for clarifying the case further. That will be all for today. Thank you so much for watching, and we hope our dear audience have learned a thing or two about the case of the Office of the Court Administrator versus LADAGA. Again, please like and share this video to your friends and colleagues for them to know more about these cases, and you can definitely comment to us about more of your discussions in this video. Have a blessed day to all of us, and goodbye for now. Thank you so much for watching.